update the amended the lordship item number 27. Upgrade lordship. If possible, lordship at 2 p.m.
Yes.
My lordship, I beg to mention item number 17 with the consent of the other side, my lordship. Here, the engaged counsel is not well. He has a major accident, Mr. D.K. Agarwala. So kindly matter may be fixed after 4 weeks.
Item 17, both sides are represented. It's submitted that the learned counsel, Mr. D.K. Agarwala, learned counsel holding the brief, has suffered an accident. Accordingly, matter stands adjourned today. Best date after 4 weeks.
4 weeks. Deeply over.
So date after 4 weeks.
Deeply over.
Yes, please. I beg to mention for item number 16, your lordship. Kindly be upgraded, your lordship. Will it be taken after motion, your lordship?
Yes.
Yes, please, your lordship. I beg to mention.
So I pray lordship item in 18 may be taken up during the course of the day.
18.
18
Contempt petition. Okay.
contempt.
Lordship, in regards to item 14, adjournment slip was circulated yesterday. I am paying for an adjournment in this matter, lordship.
Judges are represented. The prayer made by learned counsel for the appellant, the matter stands adjourned today. List after
Lordship, 2 weeks.
the date after 2 weeks. Yes.
Lordship, I beg to mention item number 1, lordship. Kindly adjourn the matter for the day.
Item number
1. Your lordship, we are going to file the substitution petition itself today.
No, without looking at the record, 2019 matter, we are not passing orders. Let us take the record. Yes, continue the prayer when the matter is called.
Okay.
Daily list item 1.
No, I will.
Both sides are represented. The learned counsel for the petition plays for further time. Do the needful as the petitioner needful to us as expired. Matter stands adjourned today. The date after 2 years.
Okay.
Item 2.
Whereabouts is not known.
My lord, in fact, I have not been made party here in this case, so a copy may be served to me, my lord. I will take the instruction.
You have hard copy and soft copy to.
Yes.
Okay, I'll get provide soft copy. Hard copy also.
Hard or soft related.
But you have to make them a respondent.
Please, sir.
He's been picked up after being declared a foreigner.
Yes, my lord.
And you are not making them parties. How will they get instructions?
Yes. He is a foreigner.
The foreigners matter. You have to impeach them. You have two choices. Number one, either to withdraw this and file it again, or number two, to file an IA, then we allow it, and only after that the amendment will come.
Usual file again, my lordship. Otherwise,
Otherwise you have to file an IA again, get it.
Union of Pura.
But Mr. S.B. Laskar, and counsel for the petitioner. In this case, the allegation is that that after being declared to be a foreigner, the husband of the petitioner, namely Islamuddin Laskar, taken into custody Is the rest to be taken into custody on 6/2/2026 and therefore what is not known. P. Sharma, and because Nigam and advocate has submitted that yes, this projected that the husband of the petitioner was declared to be a foreigner, or the concerned respondents of the board of police have not been included, for which it will be difficult to obtain instructions. Accordingly, the bank asked for the petitioner with the 6 of the court to withdraw this petition and to approach again. Matter since dismissed on the liberty as written. And in the meantime, you give him a copy, he will get an advance information.
Yes, yes.
Give him a copy and a soft copy also
Yes, my
of
lord.
this petition. Give it to Mr. Payne. He will try to get the information.
Okay, my
By
lord.
the time you file the next writ petition, it will be ready.
Yes, my lord. My lord.
Yes, item 3.
May I please, Lordship? Lordship, petition related to Lordship, missing case, Lordship, who has been missing since 27/9/2025, Lordship. Lordship, one of the nephew of the missing person has informed the police station, Lordship, Fuxor police station, but no action has been taken, Lordship. Thereafter, Lordship, very much shockingly, the petitioner found that on agreement, Lordship, on agreement has been conducted, Lordship, between the wife of the missing person and two individuals, Lordship, where, kindly, Lordship, page 15, Lordship. Where it is shown that prayer for withdrawal of case, Lordship. On missing case, Lordship. After, Lordship, this the petitioner has submitted an representation before the Superintendent of the Police, Manchester, South Salmara, Lordship. But till that, no action has been taken, Lordship. No case has been registered, no further inquiry has been made, Lordship.
Okay. Nothing to say, no,
Agreement.
notary agreement will go this way. It's just a agreement, but not notarized person.
The agreement itself, Lordship, indicates sufficient suspect, Lordship, regarding the wife.
Tell us, why are you not disclosing the nature of relationship you have with the missing person? You, in the writ petition, Yes, you say that he is a relative. In your synopsis, you say that he is the cousin sister.
Yes, Lordship.
Now, what is your relationship? Why two statements to different places?
Person,
And what is your relationship? How you are
cousin sister, Lordship.
cousin sister is okay, but how are you a cousin sister? Why at your instance we will try to find out this man? Why you are making two statements?
Lordship. It may be typically error, Lordship.
It can't be
Yes.
typographical error. Are you saying that you don't read the petition after making it ready? You just file it,
Sorry, Lordship.
then what is this typing error business?
Kindly allow me to repeat.
In a writ petition, if you can't say in the synopsis and the first, what do you call the second paragraph, if there's a mismatch, why at your instance will do it?
Then in paragraph 6, Lordship, notary agreement stated by notary agreement, but no notary signature is there in agreement.
For that, it is not his fault. He is saying that the man is missing and the wife has made a notary agreement. How is he concerned whether it is right or wrong?
No, I am saying that no, not notarized.
That we
Only
don't
agreement.
know. He thought that it is notarized,
sir.
but is a person missing.
Lordship,
Even if he gives one line information, that would have been enough.
Yes.
But we are asking him question only because he is, in one paragraph, he says relative, para 2.
Lordship,
And in the
kindly,
synopsis, he says it's cousin sister.
Cousin.
What is the
Lordship,
nature of relationship?
kindly allow me to correct, Lordship, please.
Okay, file an affidavit, bring it on record. In the meantime, we request you to find out.
Yes.
Heard Mr.
Jai Islam, Lordship.
J. Islam, the counsel for the petitioner. Also heard. For home department, you'll be appearing? You'll be appearing for home also.
Yes, 1 to 4.
Ms. R.B., Mrs. R.B. Boral, and government advocate appearing for respondent 1 to 4. You're finding a lot of problem in your petition. Number one, you are referring to this case 18 and saying that there was a compromise agreement.
Yep.
Correct?
Perfect.
Now, who is this respondent number 6 in your petition here in this page 18? Is respondent number 6 there?
Two individuals crossing. The agreement has been,
What we are asking you, please respond to that only.
yes, Lordship.
We are asking you for some reason, please respond to our query. Is this respondent number 6 there in page 18? Yes or no?
Lordship, in respect of the Lordship,
History and geography will come to later.
yes, Lordship.
We are asking you a question, please respond to the question.
Yes, Lordship.
In page 18, is this respondent number 6 named?
Lordship, in the agreement, Lordship, the wife of the missing person has been made the agreement with these two
Page 18
individuals.
is the
Lordship.
agreement.
Lordship,
Page 18 is the agreement.
yes, Lordship.
Yes. And what was the question?
Lordship, question is there, Lordship. The wife of the missing person has made an agreement with these two individuals, Lordship. What is
We are
their
dismissing the
intention, Lordship?
petition on your ground, on your failure to respond to the court query.
Lordship, the agreement itself shows so many.
We are
suspects,
asking you a question, please respond to it. Otherwise, we'll send you to the bar council.
Lordship.
We'll not only do that, we'll ask a FIR to be registered against you for misleading the court. When we ask you a question, please respond to that question immediately.
Yes, Lordship.
We have shown you page 18 and we are asking you, is this the agreement?
Agreement, Lordship.
Yes. Is respondent number 6 named here?
No, Lordship.
No.
This is the
Please.
subsequent page of the agreement, Lordship.
Please don't respond whatever not asked to you.
Yes, Lord.
Do you think in this 5 minutes we were reading this, we were gossiping?
No, Lord.
We have taken 5 to 10 minutes to see this and then we are asking you questions. Please respond to the questions. Or we'll see that your practice would be hampered.
Yes, Lord.
Don't do it. When you ask serious questions, please respond to it.
Yes, Lord.
Did you feel like that we were joking with you?
No, Lord.
Respondent number 7 is he named in page 18?
No, Lord.
How did you get their names?
Lordship, this two E-stem, Lordship. Two
Page-
E-stem I have annexed, Lordship. Page
Page-
16 and 17, Lordship.
Page 16 and 17.
Yes, Lordship.
Yes.
Morami Khatun, Shahjahan Ali, Lordship.
We have not asked you a question about Morvi. We had out number 6 and 7.
Yes, Lordship.
Where is the name of 6 Shahjahan Ali here? And page 16 you have shown us
16, Lordship. In the bottom, first party, Shahjahan Ali, Lordship.
first party.
Yes.
And you say that page 18 is that agreement.
Yes, Lordship. This is the
So where is the name of Shahjahan Ali here?
Yes, Shahjahan Ali is not mentioned, Lordship.
He is not here.
Yes, Lordship.
Then where do you get the name of respondent number 7?
7, Lordship, page 17. Jamal Sheikh, Lordship. And this paper, Lordship, perhaps it has been submitted to the police station. Here, Lordship, it is found that they want to withdraw this case, Lordship.
And this, come to page 19.
Lordship.
Is the date of the FIR correct? 26/2,
26-2.
correct? Come to page 20.
Lordship, this 26-2, Lordship, this representation has been submitted. Lordship.
That's okay.
Okay.
Come to page 20.
Yes, sir.
A representation of 26/2. How could you send it by post on 25/2? Is it 25/2?
Okay.
Tell us, what did you send on 25/2? When your representation was written on 26/2?
Mistake is there, Lordship.
Third question. It's a case of a missing person.
Definitely.
Is it compoundable
No, Lordship.
under 320 of the earlier CRPC? No. What prevented you from going to the police station and giving a statement? Even if you give a second FIR, it will be a statement in terms of the decision of, what is that? Priyanka Srivastav. And what are the two decisions? Sakiri Vasu.
Sakiri Vasuman.
What prevents you from going to the police station and giving a statement?
2008 to SEC.
Yes, Priyanka Srivastav, right? So, what prevented you from going to the police if it is not a compoundable offense?
Lordship, in some cases, Lordship, direction have been made, Lordship.
So direction is where there is seamless case. Here we have lot of difficulty. The document you are producing is not the names do not match with page 16 and 17.
Lordship, that is my
The 18,
fault,
page
Lordship.
18 does not match with 16 and 17. That's one. Second is the representation of 26% on 25th.
Lordship, these are mistake of me, Lordship, but for that purpose, party should not be suffered, Lordship. And kindly fix a date, Lordship. I can submit some citation, Lordship, where some direction has been given, Lordship. And to kindly allow me to correct pro affidavit, Lordship.
Yes, what is the decision you are giving?
Lordship.
What is the cases you are citing?
Lordship, I will submit on next date, kindly fix the date, Lordship. There is a case, Lordship, Vinod versus State,
There is a
Lordship.
person missing. Notwithstanding whatever we have said, please ask them to find out and tell you.
I shall obtain instruction.
Instructions you can please get.
Lordship, in Vinod versus State of NCT Delhi also on 2024 citation is there, Lordship.
Full citation.
Vinod versus State of Delhi.
Yes, Lordship.
Not able to find
There-
out.
there is-
Don't give the citation.
Lordship, kindly allow me to correct the error, Lordship. Pro and affidavit, Lordship.
Vinod versus State of Delhi, we are not getting any citation.
Lordship. What is the citation, Lordship? 2024, Lordship.
Cross only tomorrow.
In Supreme Court, there are 24 cases of Vinod. Does not have Vinod versus State of Delhi. In the State of Delhi, in the name of Vinod, there are 8 cases. None of them Vinod versus State of Delhi.
Kindly, Lordship. Lordship. Vinod Kumar versus State Court of NCT of Delhi on 13 February 2025, Lordship.
Vinod,
Vinod Kumar versus State Court of NCT of Delhi, Lordship.
still not there. It's a reported case.
Maybe, Lordship, I will
It's
submit,
not
Lordship, on
reported
next
case.
day. Kindly allow me, Lordship.
Okay. It's not a reported case.
And lots of cases are there, Lordship, where direction has been made out, Lordship. Although it has been specifically
Because we are talking to. Yes, yes.
Come down. Come to the end.
Lordship,
Yes, please come down.
kindly, Lordship,
We have got it. We
fix
have
the
got
date, Lordship, I will produce some.
We have got your strategy.
Yes, to the suggestion, go ahead.
My court must have been able to find it out.
So maybe, Lordship, I have. The copy is not with me, Lordship. Kindly fix a date, Lordship, I will produce some.
Yes, yes.
This is not the case. এটা না, মানে search করেছিল,
This relates to trial, circumstantial evidence. How does it relate to a missing person and orders of the court to find the person out? It's a case of circumstantial evidence. There was a person who got missing. The allegation was that perhaps it has been done away with, and therefore a complaint case, and then the conviction. The Supreme Court has turned out that conviction.
Lordship, kindly allow me. Fix the date, Lordship, I will submit some judgment, Lordship. Lots of cases are there, Lordship. Those,
Mr.
there is some.
Please come and talk for the petition and Mr. Harpi Koral, government advocate, correspondence is 1 to 4. Here made by learned one, the petition of the matter stand at 1 to 8. Next, interviewing by. The learned government advocate shall make an endeavor to obtain information as to the status of investigation of Sukhchar PS case relating to missing information of Hayat SHAIYAT, Hayat Hussain, son of Sirajul SIRAJUL Haq, HOQUE, resident of village Bataner, BATANER, next word Char, CHAR. Stated to be missing since 27/9/2025. List on 21.
Lordship. After, Lordship, This month, last week, Lord.
Tell us a date, we'll fix on that day. Tell us a date.
April, then Lordship, 2nd of April, Lord.
2/4/2026. Give us extra copy of the writ petition today itself.
Okay.
And what do you call soft copy?
Lordship, kindly allow me to.
No,
correct.
no, not now.
Soft copy दिखा.
In the just before that,
Case number.
this transfer before that, in the meantime, hard copy and a soft copy of the writ petition be provided to the London government advocate in course of the day.
Item 4.
Leave of blessing.
Deeply approved.
Wait, later of this. But the father of the petitioner is my lord, let Nirosa Sheikh, my lord. This
Yes.
the father of the petitioner, my lord, his name was Nirosa Sheikh, and his name was appeared in the voter list of 66 in 1971, my lord. What happened, my lord, after submission of the written statement, the petitioner was remain absent, my lord. Therefore, my lord, the
Where is the opinion?
opinion, my lord, 41, my lord. Yes, no judgment, my lord. May I read, my lord?
2019.
19, my lord.
Why should we entertain the writ petition now?
My lord, the explanation I have stated, my lord, paragraph 6, my lord. Page 7, my lord. The petitioner is a bona fide citizen of India by birth. He is a poor man. He was suspected to be a foreigner, and a notice was issued against him to appear before the tribunal by registering a case being entry number so and so. The petitioner was duly appeared before the tribunal by submitting his written statement. After submitting his written statement, he did not appear before the tribunal to proceed the case, as he was under impression that his case is finished, and he is not required to be appeared because his advocate did not communicate with him to proceed the case. In the meantime, the period of COVID pandemic and after COVID period, he went to Karnataka for his livelihood. When he came back to his native village in the month of November 2025, he came to know that the case was decided against him. He applied for certified copy of the impugned judgment on 15/12/2025, and same was obtained on 7/1/2026, and thereafter he engaged an advocate to file his present writ petition. Hence, he has no negligence for the delay. The delay may be condoned, and he paid for an opportunity to proceed the case before a tribunal by adducing evidences and exhibiting the documents regarding link and nationality by recalling the impugned ex parte order dated 37/2019. If your lordship, my lord, satisfied by the explanation of the delay, my lord, otherwise, my lord, all the documents are in favor of the petitioners, my lord. 3-4 documents are there, my lord, with father, grandfather, and the father and the petitioner was casted both in the year 1985. And page 13, your lordship, kindly see, my lord. Next, my lord, this left hand side serial number 3, it is Nirasa, my lord. It is the voter list of 1958, my lord. Thereafter, my lord, page 15, it is Nirasa Sheikh, my lord, for the year 1966, my lord. Then, my lord, page 22, left hand side, my lord, page serial number 44, Nirasa Sheikh, my lord, and serial number 4444, it is the petitioner, my lord. Only because of, my lord, his failure to appear before the London tribunal, my lord, this ex parte judgment was passed, my lord. Another aspect, my lord, page 34, my lord. This is the certificate by the headmaster of the Kheteswar Primary School, my lord. Till the year 1976, he was studying in this school, my lord.
Does your name and your father's name appear in any voters list?
This is, my lord, page number 22. Page 22, my lord.
22.
In left hand side, my lord, 440, my father's name Nirasa Sheikh. And right hand, 444, Hussein, father Nirasa. Principle is not there, my lord. But in the judgment, my lord, it is reflected, my lord. I have filed my written statement. Page 41, my lord. On being served the notice from the tribunal, the opposite party entered his appearance and filed his written statement. Thereafter, OP returned, remained absent without steps. He neither filed his affidavit evidence, nor does he take further steps. So this tribunal was inclined to proceed with the case against the OP above named ex parte. I have gone through the record. It seems that inquiry officer made spot verification in respect of the Indian nationality of OP Muhammad Hussain Ali, son of late Nirosa Sheikh, resident of village Bihudia under Kharupete PS district Durham. During investigation, OP failed to submit any document in support of his citizenship of India. Inquiry officer had forwarded his report to the SP border Durham on the basis of the verification report, suspecting the OP as the foreigner entered into Assam after 25th of March 1971. The SP border Durham registered the reference case against the OP. In such circumstances, learned counsel for the state submit that my lord.
We are here only to see whether the opinion of the tribunal is good or bad. Here, Lordship, after filing written statement, Lordship proceeded continuously absent, and tribunal has no option except passing this order, Lordship. Lordship, this respect, so many judgment has been passed, Lordship, by this honorable court, Lordship.
This regard, my lord,
Although-
may I pray for my lord, last one opportunity, my lord, to prove my citizenship before the tribunal, my lord.
Wrong to check on that. Wrong to check. This is a- Huh? 406.
My lord. I have obligement.
Item five.
This case, my lord, although this is not a one, my lord. Yes, my lord, may I try once, my lord. Here in this case, my lord, the grandfather of the petitioner's name was appeared in 1971 and 1966, my lord. Opinion your lordship will find page 41. The only contention is that, my lord, there are some discrepancy of ages between the petitioner, his father, and the grandfather, my lord. It is of 2022, my lord. Sahid Ali. 41, my lord. Obligement.
Item six.
May I please, lordship? My lord, in opinion is, my lord, at page 80, my lord. 24/6/2024, my lord. No, bless you.
Item 7.
Yes, your lordship, this is a contested case, my lord, judgment and order is page 37, my lord, annexure 6. Oblige.
Item 8.
May please, your lordship. Lordship, impugn opinion is page 78, lordship. 78. Lord. Sri Bhumi. It should be Sri Bhumi. Scorn of place, board of Sri Bhumi, my lord. Yes, no, it should be Sri Bhumi, my lord. Should be Sri Bhumi. Purimal is our Sri Bhumi. Block it. Block it. There was idea of the block. Yes, my lord.
Item 9.
Net is also. I've come from a limited prayer.
Here, my lord, initially I was declared as a foreigner, my lord. My brother came to this court, my lord, and in fact, my lord, the order was initially, interim order was passed, bail was granted, my lord, on 5/11/2014. Thereafter, my lord, he did not appear, my lord, in 18/1/2018, my lord, the expiry order was passed. Now, my lord, because of certain communication gaps, my lord, since he was on bail, my lord, there was no further communication, my lord, and in mail, he missed the case, my lord. He missed the bus, my lord. Now, if your lordship, the High Court order, your lordship will find at page 20, my lord. The interim order is page 17. He was under detention when he was asked to be released on bail. That's page 18, my lord. And from 19, my lord, is the order, page 20. Written statement was filed, my lord, and thereafter, written statement along with certain documents were filed. They are originally from Bihar, my lord. You want to put that? But here, my lord, thereafter, my lord, he did not appear, my lord. Although, my lord, there was, since there were no communication, my lord. And in fact, page 22 is the order which was passed in the foreigners tribunal by the foreigners tribunal, my lord. Page number 22, my lord. 22, my lord. Only thing, my lord, here, my lord, he had no knowledge. The fact remains he is an illiterate person, my lord. I have stated in paragraph 6 of my petition, my lord. The disposal of the writ petition was not within his knowledge, my lord. In fact, there was no communication with the council as well, my lord. The only thing, my lord, he is from Bihar, my lord. In the written statement, I have the certified copies of the case record, my lord. He is from Bihar. The documents from Bihar were submitted before the authority, my lord, before the tribunal, my lord. So I just pray for a chance, my lord. He's in custody since 20, my lord. He was taken into custody on 27/5/2025, my lord. I understand, my lord. I very well understand, my lord. Only thing that my lord, one chance, my lord. My lord, I'll not otherwise force your lordship, my lord. But technically, I understand my position, my lord. Now, this, earlier my brother was before this court, my lord. Now the daughter, my lord, he was taken into custody on 27/5/25, and see, he's presently in custody. My lord, had it been, my lord, he is from Bangladesh, my lord, I would not have, my lord, pressed so much, my lord. Only thing, my lord, the documents of Bihar were placed before the tribunal. I understand, my lord. That is a fact, my lord. I mean, I can place the, my lord, certificate copies if your lordship desires, my lord, of the lower court record, my lord. My lord, documents of 1962 were produced before the tribunal, my lord. Only thing, my lord, documents of 1960. I got an opportunity. That is true, my lord. No, I've been, my lord. That is why, my lord, I stated in paragraph, that is, I refer to paragraph 6 of my petition, my lord. Not that, my lord, in the 1962 documents of 1962 were produced, my lord. The voter list of 1962, my lord, showing the name of their parents and grandparents, my lord. You know, maybe, sir, so, 1949, 1949 or something.
Yes, okay. So, before arrest, proceeding never put that about the case. After arrest, he approached me, his daughter approached me for this honor. On the case that he does not aware about the proceeding lodges, 5 WS lodges.
T2. That's what I don't know. English speaking, English speaking. If your lordship requires, my lord, I can produce even the what I was insisting, my lord. The if your lordship kindly comes to page 42 and 46, my lord. My lord, land documents of Bihar of the year 1942, and in fact 49, my lord. Stamp papers of 49 are available in the name of the grandfather of the petitioner, my lord. Page 42, your lordship will kindly peruse, my lord, that is of 1942. Sorry, 1962. 1962, the voter list. Voter list of 1962, my lord, containing the name of the parents, grandparents, my lord, of the petitioner. And page 45 is a sale deed, my lord, in the name of the father of the, sorry, my grandfather. The petitioner is the daughter here. Page 46, backside of 46, lordship will find the date, my lord. Stamp papers were in annas at that point of time. Keep it. Lordship will keep it, my lord. I'll collect it later, my lord. Lordship. My lord. Deeply obliged, my lord.
Item 10.
May I please your lordship? Lordship, opinion is at page number 77. One is of dated 12/12/25.
Good. So J A secret and counsel to the petitioner and friends of the respondents. Opinion at page 77, dated 12/12/2025. Passed by so-and-so in case number so-and-so, reference number so-and-so. By which the petitioner declared to be a partner of both 25 to 1961. Notice government police, check out the details of the record. The prayer for bail is opposed by the animals for the estimated. At least time to take bail of these 5,000 is satisfactory now. Superintendent of Police Border, Dhubri. Please start for 4 weeks. On the secret tribunal's report.
Item 11.
More than 18.
Lordship. Earlier, my lord, he was declared as citizen, my lord. He is 39.
But it did not prove it. Those evidence was not tendered. No evidence was tendered.
Lordship.
That happened in 2018. You are now here after 6 years. Or 8 years. Page 39, you did not exhibit.
Page 39 was, my lord, in paragraph in the WS, my lord.
No, you are,
A written statement, page 43, my lord.
you'll have to exhibit this document. You did not do it.
In the second proceeding, my lord, after the, my lord, written statement, he did not appear, my lord.
Then if
Lot-
it is not
lot.
proved, if this document
And
is
is
not
that-
proved, then what would happen?
Nothing has been written, Lord. No. Yes, Lord, but he is registered or not, that was not there. No. Yes, Lordship. Yes, Lordship, but Lordship entered Assam in between 1/1/1966 and 25/3/19. Accordingly, it is declared that Baharal is not a foreigner who entered into Assam in between above that. Could the tribunal also, Lordship, in never exhibited this document, Lordship, although in Lordship, paragraph 19, my lord. 19 and 21. Lordship, my lord. Lordship, on earlier occasion, I could discuss this issue, Lordship, if there is not a region order, Lordship, principle of res judicata will not apply, Lordship. In WBC 251 of 2023. Reported or not? Para 6, Lordship. The principle of res judicata under the law requires two conditions precedent to be satisfied. That is, the earlier dispute must be between the same parties, and secondly, the issue between the parties must be reported or not. I have to verify, Lordship. 251 of 2023.
Judgment is created.
Decided on 3/3/2023. Lordship, para 6, para 6. The very condition that the issue must be decided requires that it must be decided by a regent order or not by an order merely depicting the view that the foreigners tribunal may have taken without any reason. From such point of view, we are unable to accept the plea of the petitioner that subsequent proceeding against the petitioner in FT case number so and so corresponding to SP case is barred by principle of res judicata. Para 6. Para 6, Lordship. Yes, Lordship. Remark করছেন যে last year.
শিখতে আছে কি কি পয়েন্টের উপরে রেবজেটিং হতো
ওটা তো বুঝতে পারবো ওটা বুঝতে পারবো কাগজের
এগুলো বুঝতে পারবো
ওই তো দিয়েছে Lordship, another decision, Lordship, this is WPC 1248 of 2023. 1248 of 2023. MD full stop Amir Ali, AMIR ALI, alias Amiruddin. Decided on Lordship 27/3/2023. Lordship. Amir Ali, AMIR ALI, alias Amiruddin. Decided on 27/3/2023. 4, 5, and 6, Lordship, I'm reading paragraph number. On principle, we are in agreement with the petitioner that the principle of res judicata would be applicable even in respect of the opinion rendered by the Foreigners Tribunal. But we have also perused the opinion dated 24/2/2016 rendered in the FT case number so and so, and have noticed that what the tribunal had done is just state and describe the various materials that had been relied upon by the petitioner in the said proceeding, and thereafter the tribunal provides that in the result, considering the entire materials on record and the discussions above, I am of the considered opinion that the opposite parties, namely Muhammad Amiruddin, are citizens of India by descent under provisions of Section 3 of the Indian Citizenship Act 1955 as amended in 2005. For the purpose of the expression considering the materials on record and discussions above, we have noticed that except for describing the materials, no reason of any kind had been given by the tribunal to justify as to why the tribunal was of the view that the petitioner Amiruddin was a citizen of India. The principle of res judicata requires that there must be a prior proceeding between the same parties, and that the said proceeding must be decided. As the second condition precedent of res judicata is not satisfied in the present case, that there is an earlier decision, we are of the view that the stand of res judicata being raised by the present petition would be inapplicable. And para 7, the second opinion ran.
The reason is Abdul Quddus.
Not good.
You have seen that judgment of Abdul Quddus.
Yes,
You have it.
Yes, yes.
Please take out.
Supreme Court. GLT 5, GLT 4, 2025 4. Part six. Supreme Court.
You got it?
At present, I don't have lordship.
You have it? You got it?
Abdul Quddus, my lord. And subsequently also, my lord, in
No,
case
you
of
have that judgment.
Tarabanu's
Is
case,
it
my lord.
available with you?
Abdul Quddus, I do not have right now, my lord.
Just open this, could those, in your, that would be, 2019,
Six
6
STC.
STC.
604.
604. 2019, 6 STC 604. Yes. Something on para 18. Come below. Further below. Just on. No, further below. Yes, 24.
Hmm.
G24.
Opinion of order of the tribunal or the order passed by the registering authority based upon the opinion of the foreigners tribunal as the case may be can be challenged by way of writ proceedings. Thus, it would be incorrect to hold that the opinion of the foreigners tribunal and the consequential order passed by the registering authority would not operate as res judicata. Both the opinion of the tribunal and order of the registering authority result in determination of rights, public status under statute and by an authority after a contest on merit, which should necessarily operate as a bar to subsequent proceedings before the same authority for redetermination of the same issue of the question. The court in Ujjambai, Farka state of UP, has held that the
This
principle of
state of UP, this case is 1962.
yes, Lord.
You're aware of it.
Yes, Lord.
You're aware of the strength of the bench.
Lord.
Are you aware of the strength of the bench which has given the judgment of Ujjambai?
No, Lord.
It's a 7-judge bench. Just click on 4. Yes. This is AIR 62 SC 1621. You go below, down below. Yes. Okay, it's not highlighted. Then please search AIR 62. Make it to left side. One eye, then I can put it. 161. Yes. This is a 7-judge bench.
Yes, sir.
So Supreme Court special bench of 7 judges says the judicata applies,
Yes, sir.
followed by Abdul Quddus, which is a 3-judge bench.
Yes, sir.
Are we bound by the 2 cases you have
No,
cited?
no. That is not correct, but Lord, hey,
Hey,
what I am submitting is that
No,
Lord,
you can challenge it. This opinion can be challenged because this the other judgment of Rukia Begum, that is very clearly said. This opinion could not have been given. It's palpably wrong. For you to challenge it,
yes, sir. It is our fault, but Lord,
send it back. It has to go back. We can't say ignorance of law. 7-judge bench we can't omit.
yes, sir. So, Lordship, but Lordship, my humble submission is that Lordship, in a suo motu case, what was the view of the court, Lordship? Just I'm reading para 6 of WBC suo motu 11 of 2017, Lord.
Yes. Yes.
Lordship, in a suo motu case, Lordship, WPC suo motu 11 of 2017, Lordship. Paragraph C.
No, in those cases, so what it was taken up.
Yes, Lordship.
Was under different circumstances at that point of time.
Yes, Lordship.
Correct.
Lordship.
You can take help and then find it appeal because
Yes.
so we can't incorporate this case there. Possibly wrong, horribly
Yeah.
wrong, but still, you know why we were showing you that last case of Abdul Qudus.
Yes,
Can you
Lord.
please come back to that Abdul Qudus again? Madam, please go back to that Abdul Qudus. 2019,
19. 663, 604.
604. In para 24. Yes, after that, we stopped at Ujambai.
Yes.
Read after that.
The
This
court
court in
in
Ujambai,
Ujambai versus State of UP has held that the principle of res judicata equally apply to a quasi-judicial bodies. Whenever a judicial or quasi-judicial tribunal gives a finding on law or fact, its finding cannot be impeached collaterally or in a second round and are binding until reserved in appeal.
viewers,
Reversed in appeal
appeal
or by way of writ proceedings. Yes,
the
Doctor.
correction appeal of the Judicial Act or finds whether right or wrong.
Yes, Doctor.
Thus, any error, either of
Yes.
fact or law, committed by such bodies cannot
Can
be
be
controverted
Otherwise, by way
otherwise
of
by way of an appeal or a writ, unless the erroneous decision relates to the jurisdictional matter of that body.
yes, Doctor.
This is the of the three judge bench of Supreme Court.
Yes, Doctor.
Send it back. If you can challenge that order.
Yes, Doctor.
Then always give an opinion. Heard Mr. R. Anil and also for the petitioner. Also heard so and so for the respondents. Next. By filing this petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated page 51, dated so and so, passed by so and so in. There are three references, so and so, so and so, and so and so, by which the petitioner was declared to be a foreigner of post 25 in 1971 stream of the contents of the said opinion reveals that though the petitioner had filed his written statement, but he did not tender any evidence, and therefore the said learned tribunal, taking note of order 3 within bracket 4 of the foreigners within bracket tribunals bracket close order 1964, pass the opinion on failure of the petitioner to discharge his burden of proof as envisaged under section 9 of the Foreigners Act, 1946. Next paragraph. As there is an inordinate delay of 8 years in assailing, about 8 years in assailing the said opinion, the learned counsel for the petitioner was asked to address the court on the delay and damages. To stop. It has been submitted by the learned counsel to the petitioner that there is an inordinate delay in assailing the said opinion, but he places reliance on an earlier opinion dated 9/12/1999, passed by the Foreigners Tribunal, Dorong, Mongoldoi, page 39, in FT case number so and so, within bracket SP inquiry number so and so, by which the petitioner was held to be not a foreigner who entered Assam in between 1/1/1966 and 25/3/1971. And accordingly, he was declared to be not a foreigner who entered Assam in between the said dates. It is further submitted that as there already existed an opinion declaring the petitioner to be not a foreigner, the petitioner was under a bona fide impression that his learned counsel would take care of the proceedings, and in the month of November 2025, when the state started taking action against the declared foreigners, he contacted his learned counsel and came to know about the opinion already rendered on 31/5/2018. Next, the learned standing counsel for the FT and border matters has submitted that the previous opinion dated 9/12/1999 is an absolute non-speaking order, and without discussing the evidence, it has only been mentioned in the said opinion that on a perusal of the Gauhati certificate dated 28/4/1999, certifying that the petitioner, Bahar Ali, is the son of Dulu Sheikh, whose DULUSEIKH, whose name appears in the electoral roll of 1956. Petitioner was declared to be a foreigner, as to be not a foreigner, entering into Assam in between 1/1/66 and 25/9/1971. Accordingly, that that opinion is not sustainable either on facts or in law. We continue post lunch. I have a meeting right now.
You see.
You're bully.
Oh, yeah, yeah. আপনার কোন ঘৰ দাদা? অ, আজি কিমান তাৰিখ? 18।
ইয়াতে দি দিলে হ'ব ন? Accordingly, by referring to the decision of this court in the case of Rafiqul Islam, RAFIKUL, Rafiqul Islam versus Union of India and others, 2023, within bracket 3, bracket close GLT 911, and Mohammed Amir Ali, AMIR, Amir Ali, alias Amiruddin, AMIRUDDIN, WPC 1248 of 2023, decided on 27/3/2023. It is submitted that if the opinion expressed by the Foreigners Tribunal is a non-speaking order without any discussion of facts of law, the principle of res judicata would not apply in respect of such orders. This also submitted that in view of the inordinate delay in assuring the impugn opinion, no interference with the said opinion is called for. Consider the materials available on record in this writ petition. it would be, in order to deal with the submissions made by the learned standing counsel for the FT and border matters, it would be appropriate to quote the opinion dated 9/12/1999, page 39, passed by so and so and so and so. Next one. From the above. Although we find some force in the submissions made by the learned standing counsel for the FT and border matters, that the previous opinion is based merely on a certificate of account, certificate dated 28/4/1999, issued by the Kampura, which is contrary to the law laid down by this court in a criterion of cases, where it is stated that the Kampura certificate or in full testimony of the witness stating the proceeding to be the standard is inadmissible in evidence. So how, even though the even if, assuming that the learned standing counsel for the FT and border matters is correct, that the said opinion dated 9/12/1999 is a non-speaking order, yet the court is bound by the observations made by the Supreme Court of India in paragraph 24 of the case of Abdul Quddus versus Union of India, within bracket 2019, bracket was 6 SSC 604, which is extracted herein under. It is observed in the decision, in the observations of the Supreme Court of India in paragraph 24 of the case of Abdul Quddus, within bracket Sushma, that the Supreme Court of India had referred to the judgment of Jum by UJJAM, BAI, this is state of UP and others, from a 1962 SC 1621. So the said judgment is a judgment by a 7-judge bench. In the aforesaid paragraph 24, or the 3-judge bench of the full bench of the Supreme Court of India had clearly held that the characteristic attribute of a judicial act or decision is that it binds, whether right or wrong. So therefore, even if this court may not agree with the nature of opinion expressed expressed on 9/12/1999, but it has a binding character, and therefore the said opinion would track the principle of res judicata in the subsequent proceedings. Next one. We hasten to add that notwithstanding any observations made in this order, still be open to the state to take the call whether or not they would allow the state opinion dated 9/12/1999. That. Next one. Insofar as the present case is concerned, notwithstanding that there is an inordinate delay and that is on part of the petitioner to ascertain the opinion dated 31/5/2018. But as the principle of res judicata applies, the court is of the considered opinion that the petitioner deserves a chance to participate in the proceedings of the subsequent case of FT. This is at page 51. FT court case number 76 SPR 2017. Next. It would now be appropriate to deal with the cases of Rafiqul Islam, Supra, and Muhammad Amir Ali, alias Amiruddin, within bracket Supra, cited by the learned standing counsel for the FT and border matters. It appears that when these matters were decided, the full bench decision of the Supreme Court of India in the case of Abdul Quddus within bracket Supra was perhaps not placed before the bench. So, therefore, as the finding of the full bench of the Supreme Court of India in the case of Abdul Quddus within bracket Supra would find this court the decision in the case of Rafiqul Islam within bracket Supra and Muhammad Amir Ali alias Amiruddin being contrary. We all laid down in paragraph 24 in case of within bracket Supra. The court would be more inclined to follow the full bench decision of Abdul Quddus. Decision of the Supreme Court of India in the case of Abdul Quddus. As already indicated above, as the court is of the view that the petitioner deserves one chance to participate in the proceedings of court case number 76 of the SPR 2017, 851. The court is inclined to pass the following orders. That the opinion dated 21/5/2018, 850 passed by 73 is hereby set aside. Petitioner will be represented by his learned counsel. Is directed to appear before the said learned tribunal on or before 3/04/2026 and file his evidence on affidavit and also the evidence on affidavit by any other witness. As per desire. on the appearance of the petitioner. And from 3/04/2026, the said learned tribunal shall make an endeavor to because of the proceedings within a period of the period as prescribed in the other three in the bracket 14, the foreigners within bracket tribunal, on 94. Required by taking day to day proceedings. Next one. In the event the petitioner fails to appear within the time allowed or on any other date fixed, it would be open to the said learned tribunal and treat the petitioner as absent on shore and pass such orders as pertains to the penalty. Next one. In view of the inordinate delay, we direct the petitioner to deposit cost of fees 5,000 before the secretary, member secretary from our legal services authority, Jalangat Mangalday, within 30/4/2026, and produce a copy of the receipt of such deposit before the learned foreigners tribunal. Next, as the payment of cost is made a precondition of setting aside this order, in the event the cost is not paid, it would be open for the learned tribunal would have liberty to reject acceptance of the evidence from affidavit unless the same is accompanied by a copy of money receipt and deposit of such funds. Please. This order has been passed without issuance of notice on the respondent, the devotion stage. And by producing a certificate copy of the order, can also find evidence on it. Produce a certificate copy of the order and shall also file the affidavit. Next paragraph. This it is made clear as indicated above, it is made clear that this order would not come in the way of the state to take a call on the opinion dated 9/12/1999 as by page 39. Next, this requisition stands allowed to the extent as indicated above. With cost of with costs as most against the petitioner is ordered. They're giving liberty to the state. If they want to challenge this opinion, they can do so. And 5,000 cost, you have to deposit as a precondition before the district legal services authority.
Item 12.
Oh, Mr. Ali. Mr. Ali. I forgot that 71, 1666 that I forgot. Mr. Ali, there's something I forgot by dictating the order. I've forgotten something which was required. I've said something that this. If I started this dictation today, now I've said that the the state can challenge the order. You add there. This observation is made in view of the fact that this court, in the case of Rukia Begum, RUKIA, Begum, what is that citation?
Rukia Begum, 2000.
Give me the citation, huh? Rukia Begum, others, so and so, versus the Union of India and others, so and so. This court had
2023 for GLT 1208.
2023
For GLT 1208.
GLT
1208.
1208. This court had Begum, BARBHUIYA, alias Rukia, RUKIA, Rukia Begum versus Union of India. That is what it was. This court had discussed the law relating to the foreigners within bracket tribunals, bracket close order from 1964. And section 2 within bracket 1 of the foreigners, one of the foreigners, the order, and 2(8) of the Foreigners Act from 1946 and Section 6, capital A of the Citizenship Act from 1955. And has held that the reference before the tribunal can only be within the scope of the foreigners order 2 within bracket 1 of the foreigners within bracket tribunals bracket was order from 1964 read with section 2 within bracket A of the Foreigners Act from 1946 as to whether or not a person is a foreigner. Notwithstanding that, the reference was to the effect as to whether the petitioner, whether the proceeding had entered state of Assam between 1/1/1966 and 25/1971. So we take it clear that this observation shall not be construed as a finding of the court on the merit of the opinion dated so and so, that page 39. That much in our thinking. Yes, item 12, my lord. In order, it may at page 74. now. Seventy-four, heard Mr. A. Hussain, learning counsel for the petitioner, and so and so for the respondents. Opinion dated 12/9/2023, case 74, passed by so and so, in case number so and so, police reference number so and so, by which the petitioner was declared to be a foreigner 25/3/1971. Notice returnable in on so and so, give of this date, returnable so and so, extra copies in 2 days, or for the records to following email address. Prepare for bail shall be considered on receipt of the tribunal's records. Next, in the meantime, if the petitioner, Mrs. Sohiran Mesa, alias so and so, is apprehended, she shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a certified copy of the order before the superintendent of police border Dhubri. My lord, Dhubri. This conference.
27th April. Item 13.
I can define subject matter numbers. Here, I have paid for hospital some investigation team located by some high officers. Because the present investigation, the IO has done nothing, madam. FIR is for the page 190. 134. Revision from 137.
FIR.
Where is the FIR?
132. I'll go in. Very well.
Which page you said was the FIR?
137.
Oh, I'm sorry, I'm reading something else.
Mary,
Just a moment.
10 days.
Authorized. Yes, madam.
Or for transfer of 100 of transfer of the said case to any other independent agency before issuance of notice. Court is inclined to call for a status report of investigation of the said case. Next, we run it additional senior government advocate placed for 10 days time. Next, let the said report be produced from the next date of this thing. Next, the learned additional senior government advocate shall transmit an order of this order to the officer in charge of Bhagar Police Station would ensure that the IO sends the status report of the investigation to be produced on the next date of listing before this court. Next, list on, give a date after in this. 1st of April.
1st of April.
First of
Supply item 22.
May I please, Your Lordship?
yes,
Yes, my lord. In this case, my lord, there was a delay of, my lord, 6 years, my lord, for preferring the writ petition, my lord. Because of the extreme poverty, my lord, the petitioner could not prefer the writ petition, my lord. And his, my lord, husband is also a daily wage earner, my lord. Somehow he is managing his family, my lord. I explained the delay, my lord. And in the similar circumstances, my lord, this honorable court has,
what is the husband, we couldn't hear it. Is your speaker on?
speaker is on, my lord.
Yes, please say again.
The husband is a daily wage earner, my lord. In fact, my lord, even though they got the certified copy of this order on 25th of July, my lord, 2025, but the writ petition has been preferred, my lord, in the year at the beginning of 26th, my lord.
And what is the best document you have to connect you to your projected parents?
The land documents, my lord, the land, down on the copy, my lord.
Which page?
Yes, my lord, I know. Yes, my lord. My lord, this is page, my lord, 34, the vernacular is at 35, my lord. My name appears at serial number, my lord, 59, my lord. Which will, lordship will find it in vernacular.
Where is your written statement?
Yes, my lord. The next page, my lord, page 38 is the written statement.
Hmm?
Page 38 is the written statement. Annexure 7, my lord.
Page 38.
Yes,
Is
of
your
the repetition. Yes.
Yes, my lord. Yes, my lord. Yes. Four sons. Yes. And then Aisha Khatun, Samartha Banu, Mesa Begum, Kulsuma Begum, and Saleha Khatun petitioners. My lord, may I pray for one thing, my lord? In a similar circumstances, my lord, this honorable court recently has passed an order, my lord, at the motion stage, that there was a delay of more than 4 years, my lord. And it was directed in the, my lord, in the interim, it was given that the petitioner shall not be deported out of the country, since she appeared before this honorable court after 4 years, my lord. It is similar. Therefore, my lord, since the case is at motion stage, my lord, I am praying before your lordship, my lord. If the case is posted in admission or hearing stage, till then, my lord, she may not be, my lord, deported out of this country, my lord. This was, my lord, passed recently, my lord, 12th of November, my lord, 2025. And there was a delay of more than 4 years, my lord. Yes, my lord. That's what I'm praying, my lord, at this stage, my lord. Motion stage, my lord. That will be posted in the admission hearing, my lord, but she will take a decision thereafter. Yes, I'll leave it to your lordship. I'll leave it to your lordship. Bye.
Item 23.
Deep left.
Met this version. The judgment is of 2018, my lord. What happened, my lord? I have appealed Please, your lordship will find page 41. What happened, my lord? I have filed my WS. Evidence was filed. My father has filed evidence. However, my lord, during the cross-examination, both the witnesses were absent. Therefore, the Ladder Tribunal came into the finding that, my lord, the case was not proved. The lordship will find page 44 at paragraph 3, my lord. On perusal of the order sheet, it appears that the opposite party, taking various pleas of dilatory tactics adjournment to delay the proceeding without subjecting herself for cross-examination, despite reasonable and sufficient opportunity was given to the opposite party under section 137 of the Evidence Act. The main object of cross-examination is to discover truth and exposing falsehood. The evidence of OP who had not subject herself for cross-examination by taking various tactics, my lord, cannot be made use of proof unless completely cross-examination. Hence, the evidence in chief on affidavit and failure on the part of the OP subject herself for cross-examination is it admissible in evidence and cannot be acted upon as trustworthy. Accordingly, having no other alternative and the reference case is heard as ex parte. As such, the case is heard as ex parte and posted the case for ex parte final order on 21/12/2018. My lord, at this stage, my lord, may I pray, my lord, some opportunity may be granted for facing the cross-examination, my lord. My lord, delay is there, my lord. That I am admitting, my lord. Explanation, my lord, for delay is 7, my lord. That poverty and ignorance, my lord. Although, my lord, that cannot be accepted by my lord, lordship, because my father name was all probably, my lord, appeared in Bhuta list, my lord. At page 13, the name of my grandfather was appeared, my lord, in the year 1965, and page 17, the name of my father was appeared in the Bhuta list of 2011. Lordship, kindly see the page 13, my lord. This Keramat Ali is my grandfather, my lord. And page 17, Ismail Ali, son of Keramat, this is my father, my lord. This Ismail Ali, my lord, my father has deposed before the tribunal, but my lord, unfortunately, my lord, the cross-examination he did not face, my lord. That much opportunity I am praying before lordship, my lord. My lord, because my lord, this opinion of the Ladder Tribunal is on technical ground, my lord. No, my lord, there is no evidence, my lord. That is why the tribunal did not enter into the merit, my lord. Only technicality, my lord. My lord. There is a admit, my lord. Delay is there, my lord. But my lord, that is why, my lord, I am praying lordship discretionary power, my lord. Give me, my lord, one chance, my lord. I will, my lord, prove my nationalism before the, my lord, tribunal, my lord. Because
Lordship, since 2018 to Lordship May 21/12/2018. petitioners take so many adjournments. Then it was not, it is the tribunal did not give him chance for cross-examination. So many adjournments has been taken in the name of cross-examination lordship, and after that lordship tribunal passed this opinion lordship. Para to lordship clearly goes from only things lordship. Para to only opinion-based potential.
If your lordship there is the order, my lord, only technical, my lord.
Last time was also granted lordship. In order to delay Luxus in listening the impugn opinion dated 21/12/2018, page 41. List count 25, he got the delivery orders.
I have deeply blessed.
Item 24.
May I please, your lordship. Here the impugned opinion is at page number 30, lordship.
Just a moment.
My lord, the impugned opinion is at page number 30, dated 31st of December 2025. Page number 30, my lord, Annex 1.
Thirty-one 12/2025, passed by so and so in case number so and so. Police inquiry number so and so, by which the petitioner was declared to be a partner post 1997. Notice extra of the records. Therefore, bail is opposed by the Royal Standing Council for the other matters. Single position, and this time to take bail is 5,000 to the satisfaction of Superintendent of Police Border,
Gauhati.
Gauhati. 4 weeks.
Alia.
Usually.
Item 27, the upgraded item.
Petition. May please, your lordship. In this case, lordship, the petitioner has some document, but at the time of issuing notice from the tribunal, lordship, he only submitted his written statement, lordship. And thereafter, he could not contest the case by adducing evidence, lordship. So ex parte judgment was delivered by the learned tribunal, lordship. That is page 52, lordship.
52.
52, lordship.
52. Yes.
This is the first judgment, lordship. Thereafter, review application was filed along with a condonation application that was also rejected, lordship. And thereafter, writ petition was filed before this honorable High Court.
Just a moment. Where's the review order?
Review order, page 62, annexure 15, lordship. 17/12/2015. As he has taken some ground of medical, lordship, but no medical documents was enclosed along with the condonation application. So review petition was also not considered, lordship. Page 62 and 63, lordship.
Yes.
Thereafter, lordship, writ petition was filed. Writ petition was dismissed, lordship, page 65. Paragraph 8, page 66, relevant, lordship, the findings. The same ground was upheld by the writ court also, that no medical document was enclosed with the condonation application. So the OP failed to prove his case, lordship. Paragraph 11, having regard to the law laid down by the full bench in Muslim Mandal, we find no error or infirmity either in the order dated 1/7/2010 or in the order dated 17/12/2015 passed by the tribunal. Writ petition is devoid of merit and is accordingly dismissed. Thereafter, lordship, the petitioner approached the Supreme Court. Honorable Supreme Court also dismissed the special leave petition. That is annexure 17 and 17A, page 68 and 69. Citation or launch. Page 68, lordship, this petition was called on for hearing today. List the matter again on 28 July. On 28, page 69, delay condoned, the special leave petition is dismissed. So pending applications are disposed of. Lordship, when they approached me, and lordship, one criminal petition was filed before for the petitioner before this honorable High Court. WPC criminal 30/2025. That is annexure 19, page 71. Page 72 is the order, lordship.
Yes.
So, lordship, as per this order, lordship, he was handed over to the border security force after declaration of foreigner, lordship. He was taken into custody, but lordship, when the Honorable Supreme Court, at the time of COVID time, lordship, there is an order from the Honorable Supreme Court. And as per this order, lordship, he was released from the jail, page annexure 18, page 70, lordship. And thereafter, when he was again taken into custody by the police station, then the writ petition was filed. And as per information from the writ petitioner, Lordship, he was taken into custody and he was taken to the area of near Kusbihar, Kukrazhar or that part, Lordship. Then in the morning, he again returned back to his home, Lordship. So when they approached me, Lordship, I have asked them to bring the order sheet from the Honorable Tribunal, Lordship. The order sheet reflects that, Lordship, after receipt of written statement, Lordship, no date was fixed for reducing evidence, Lordship. Page 48 to 51, I have enclosed along with the petition, Lordship. The petitioner is constantly trying to prove his case, Lordship, but maybe due to some, Lordship, proper advice, he could not prove his case. Page 48, your Lordship, kindly see annexure 11.
You see, come to the page 49, that is the
Lordship,
page, come to page 49.
original, Lordship.
Yes.
After service, OP appeared on 8/7/2009
Yes.
and
Okay,
filed
yes,
a petition.
This. Then 11/8 files WS.
Yes,
Sit for
Lordship.
hearing.
Yes, Lordship.
Now, is the, after that, the OP is absent, and is being fixed for hearing.
Yes, Lordship. The case was directly fixed for hearing, but after that he remained absent. And thereafter, after hearing, the case was, Lordship decided ex parte.
Correct.
So, Lordship, I am praying only one chance may be given to the petitioner to prove his case.
This orders, page 52, 62, 64, 68, 71.
Lordship, he is constantly trying since 2010, Lordship, to prove his case, Lordship.
No, the tribunal did not refuse to accept your evidence.
Yes, Lordship. There are some dates on which he could not appear before the tribunal. In the condonation application also, he had approached the court with a review application, with condonation application apprising that due to some medical problem, Lordship, he could not remain present, but that was not considered. So my humble prayer before your Lordship, though there are some sort of lacuna, Lordship, on the part of the petitioner, that may be condoned, and Lordship, he may be given only one chance to prove his case, Lordship. As Lordship, since 2010, he is fighting for justice, Lordship. And he has some documents which prove that there is no other member in his family a foreigner, Lordship. His brother, sister, father, mother, everyone is Indian citizen, Lordship. There is no other case pending against any of the family members. So only I am praying and one chance may be given to prove his case, Lordship, by adducing the evidence.
So we can just talking clearly. Very ground that all logic and logic.
Lordship,
You have not felt the ground on which you are preparing this review. What is the ground for review?
Lordship, page 11.
What is your ground? Tell us the ground.
Page 12, Lordship, ground number 4, that the learned tribunal passed the ex parte judgment only on the basis of the written statement and held that the petitioner though submitted the written statement but failed to adduce any evidence to prove his case, but it was never brought before any of the courts that the petitioner was never given any chance by the tribunal to adduce any evidence in chief or to adduce the evidence of any other parties to the proceeding. That was the ground I have taken in my review, that after going through the order sheet, I have seen,
Asking you a question.
Lordship,
There's a writ petition.
Lordship,
We issued a notice yesterday. Today you have appeared, you have not filed your affidavit in opposition.
Lordship,
You don't seek time to file any affidavit in opposition. And your appearance is complete.
Lordship.
Now, will this court be horribly wrong in saying that no evidence is filed, therefore list on so-and-so for hearing?
Lordship,
Is it an incorrect order?
Lordship, my prayer is that Lordship, though he submitted his written statement, but no evidence was
Somebody tried to
adduced.
tell him to file an evidence.
Lordship.
Is it?
For
No.
some dates, he remained absent, Lordship. That is,
The case will be, you see, the hearing starts at the stage of framing of issues.
yes. From the order sheet, it reflected that, Lordship, on the date of submission of written statement, Lordship, it directly fixes for hearing. Lordship.
Correct. What is wrong?
On that day, Lordship, written statement was submitted. The engaged counsel was present, Lordship.
But since then, for so many dates, they were not there.
Lordship.
Is it a case that you wanted to file an evidence that was refused? That's not your case.
Lordship. Only had it been a case that the next date was fixed for evidence and then he remained absent, Lordship. Lordship. Lordship.
See, the case is fixed for hearing, means if the case is fixed for evidence.
Normally, Lordship. Lordship, normally, Lordship, it fixed for the evidence adduced by the OP, Lordship. Hearing means after completion of the evidence in chief and cross of the OP, Lordship.
No.
Lordship. Sometimes, Lordship, hearing. Lordship. Lordship. For that only, I have admitted that there are some sort of lacuna on the part of the petitioner, Lordship, after condoning that if possible, Lordship, one chance may be given to the petitioner, Lordship, to prove his cases, because he is fighting since 2010, Lordship. And only if after reducing evidence he failed,
See,
Lordship, then there is,
My sister has asked you a question for a reason. This,
Lordship, after hearing means the, to reduce the evidence and all this.
you read this. Chapter 18. What is the heading? Order 18. What?
Hearing of the suit and examination of witnesses, Lordship.
So it is always hearing of a case and then examination of witness.
Lordship.
So court may not give you a date specifically for a hearing, for giving evidence.
Lordship.
Because this is inherits in it
Lordship.
the right to file an evidence.
Lordship. But
But if you
in
don't
some
file-
of the tribunal's order
That's
sheet, I
okay.
have found that, Lordship, the, to adduce the evidence of
Maybe
the
I'm
OP,
saying
Lordship.
it's wrong, but this is the reason.
Lordship, for that only I am admitting that there are some sorts of lacuna on the part of the petitioner, Lordship, but by condoning that if possible, Lordship, one chance may be given, he will try to, Lordship, prove that he is an Indian citizen. His father is an Indian citizen and there is
Sort of,
no
we are
other,
fixing it on same day, 25th, because we have tied up with some work.
Lordship.
Mrs. Chaudhary doesn't come to the petitioner and so and so the petitioner. You have been noted a delay in presentation of this review application. Sir, review application against the order dated 5/1/2017, passed in WBC 7581 of 2016.
16, Lordship.
Both sides were heard on the issue of delay and latches. This is on 25, 320, sorry, 23, 25, 320, sorry,
There are some other matters, Lordship, only on the same issue, or your Lordship is fixing it,
I'm fixing it on same day because these few days I am tied up with some work.
Lordship,
Will not be able to
Lordship.
pass orders. It's not like usually work which we are tied up.
Obliged, Lordship.
There was one more request for upgradation, but we can't take it. We have to rise for the single bench. That's already, your matter also will have to be adjourned. Will have to be refixed.
And item number 21, Lordship.
The court must still fix a date. We are, because these few days we are having some administrative works.
My item number is 16 year lordship. 16. It
Item
was item 16,
16.
16.
Just see, few days, some best practice. Tied up with some. Just this.
Lordship, if it can come any of this,
Not right. Your item was item number
80.
18.